the first thing I'd like to talk about is the taxes, because everyone's always concerned about taxes. So in 2020, this year, the exemption from the federal estate tax is $11.58 million per person. So a married couple can shelter over $23 million from federal estate tax. So for most Americans, the federal estate tax is just not an issue anymore. If the law is scheduled to revert back to its old limits in 2026, but even that's a large number. That number is based upon what it was in 2016, adjusted for inflation through 2026. So it'd be around, probably, I'm making a guess, per person is probably an exemption of around $6.5 million per person. So again, most Americans will not have a federal estate tax. If you do, there are other things to plan for. I'm not going to get into that today, but there's other planning tools to reduce or possibly eliminate the federal estate tax. But again, that's not for today's topic. The Ohio estate tax disappeared in 2012. So there's no Ohio estate tax. So for most people, death taxes are not part of the planning. Now, income taxes have become more relevant in planning. Let me give you the reason. It's called the step up of income tax basis rules. Let me explain those. If you bought Google stock for $1 and it grew to $1,000 and you sold it, you'd owe capital gains on $1,000. If you gave that Google stock away, let's say to your children, and they sold it, depending on their tax bracket, they would owe capital gains. But if you die holding that Google stock, all the capital gains are wiped out. So for a lot of estate plans were designed to save federal estate taxes, they couldn't take advantage of that step up of income tax basis rules. So if you have an old estate plan, you may be planning for something that's irrelevant, the federal estate tax, when you should be planning to help try to avoid extra income taxes. So generally, if you have an older document and your estate has any sort of appreciated assets in it, you really want to re-examine that based on all the changes. So that covers taxes. I'm not going to talk about taxes anymore, but I wanted to mention that. I am going to talk about, probate. Probate is paperwork. Bill Gates can avoid probate. He can't avoid the federal estate tax, but he can avoid probate. So what is probate? It's the paperwork for, let me give you an example. I give an example of the outline. Amanda has a simple estate, maybe a house worth $150,000, $30,000 of stocks or bonds, mutual funds, some CDs, and she wants to distribute everything equally among her 3 children. So her will says, I give everything to my 3 children. But she does nothing else. We're going to have to probate it. Probate is the paperwork, and it costs money to probate. Typically, you hire a lawyer to do this sort of stuff, so you have legal fees. You have executor fees, that's statutory, that's a percentage of the size of the estate. You have to do a lot of paperwork, notice to beneficiaries, probate court filings, inventory filings, possibly appraisals. All those things cost money and time, and they stretch out the process. And finally, probate is is a public information. Anybody is allowed to go around the probate court and look at all the information you file. Matter of fact, a lot of it's right on the internet. You're allowed to pull that off offline. So you can, if you go through probate, you're going to have time and extra expenses and a lack of privacy. Most people want to avoid probate. There are very few times that people actually want to go through probate. Most want to avoid probate. So let's talk now. Let me talk about ways to avoid probate. Now, a trust, which I'll talk about, is obviously one way to avoid probate, but not everybody needs a trust. A trust is one of many tools to avoid probate, but not the only one. There are a lot of other ways to avoid probate. Beneficiary designations on your IRAs and your life insurance. I'm going to talk about that. Matter of fact, I'm going to flip to the next slide because I just want to, well, I guess I won't flip to the next slide. Go backwards. I'll get to that later then. So there are a lot of different beneficiary forms for life insurance. Real estate, you can have what's called a transfer and death affidavit. You name a beneficiary of your real estate, that avoids probate. Annuities, you name beneficiaries. Bank accounts, you can make them payable on death. You're naming a beneficiary of your checking account or your savings account or your CD. It avoids probate. It goes to whoever you name the beneficiary, that's who it goes to. About every asset you can think of, you can name a beneficiary. And that avoids probate without the use of a trust. And for many people, that's enough. In a simple situation, that's very easy to do. So for example, in the next example on the slide, Mary has a home, a couple duplexes, an IRA, a bank account. She has 1 child. So what she does is she doesn't want to do a trust. She wants to avoid probate. She names her daughter as a beneficiary of the bank accounts on the real estate, the home, and the duplexes. She files with the county what's called a transfer death affidavit that names the beneficiary of the real estate, and on her death, it automatically goes to that child outside of probate. There's a little paperwork you file with the county just to indicate that you've passed away, and then she's the title holder to that real estate. Bank accounts, she goes to the bank with a death certificate, they give her the money. IRAs, annuities, the whole 9 yards. Very easy. A very easy way to avoid probate without a trust. And for many people, that's all you need. However, there are some situations where it's just too complicated to use beneficiary designations. So in my next example, Mary has 4 children. Three have been married, 1 who predeceased Mary, and that child had some young children, that young child. So now what happens? Well, with the beneficiary forms, it's more complicated. Real estate, let me give that an example. So the real estate, the duplex in my example, goes to the 3 children who are alive and married, and the 1 minor. Under Ohio law, when they try to sell that property, not only do they need the signatures of the 3 children, they need the signatures of the 3 children's spouses. So right there, that's 6 signatures. And they need the signature of the minor child who cannot sign for themselves. So there's going to have to be a guardianship put in place, and or a custodial form, and that's going to have to be signed by that custodian or guardian. A lot more paperwork. Also, any decisions regarding the house aren't by majority rule. So if they want to sell the house for $180,000, they all have to agree. They can't do, hey, let's raise our hands and the majority wins. So it's not as convenient way to avoid probate with a beneficiary designation in many situations when you have multiple children or a more complicated estate. It can still avoid probate, but it may be more complicated than you had intended. So that's those people, then they might want to consider a trust, because a trust, you name one person the boss, one trustee, and they can sell the real estate. They can determine the price. They divvy up the proceeds among the beneficiaries. It's much simpler administratively in that situation because you have multiple beneficiaries. It all depends on your situation. There's not a one size fits all. You have to decide whether you can avoid probate easily enough with the beneficiary forms or whether you need something more complicated than a trust may be the answer. Again, if you have any questions, raise your hand. I think I'll be able to see if you raise your hand, or type in a question and I'll try to answer them as I go along. Now, as I mentioned, there are a lot of different types of assets that avoid probate: life insurance, IRAs, and annuities. They're governed by the beneficiary form, and that's governed by Ohio law. 401k plans or pension benefits are governed by federal law, ERISA. And again, you need to fill out a beneficiary form. Now, the issue here is you should always review your beneficiary designation forms at least annually. Make sure they do what you want them to do, that you've named the beneficiaries you want. The reason for that is Ohio law says if you've named, let's say, your spouse the beneficiary and you get a divorce, you've named your spouse the primary beneficiary, you've named your children the contingent beneficiary. You get a divorce. Ohio law presumes that your spouse is dead. You've been divorced, so she doesn't inherit that. I'm going to use the wife as the beneficiary. The wife divorces the husband divorces the wife. The wife is deemed dead for purposes of the husband's beneficiary designation, so the assets will go directly to the children. That applies to IRAs, life insurance, annuities, transfer on death affidavit that I talked about. It doesn't apply to 401k plans under ERISA. Any pension benefit or 401k benefit that's governed by federal law, the federal law takes over, and the federal law doesn't care whether you got a divorce. If your wife is named the primary beneficiary of your 401k and then you get a divorce and you don't change that beneficiary designation, she will inherit that money, which comes as a big surprise to the children after the fact sometimes. So you want to look at this stuff and make sure you're aware of what beneficiary designations you have. Any questions on that? Okay, again, feel free to type in your questions. There was one, okay, so someone has one question about what happens if you remarry and your 401k and you haven't changed your beneficiary designation. Well, the federal law requires that the spouse be the primary beneficiary of your 401k. So if you remarry, technically it should be even if you haven't changed it, I suspect the court would rule that your new spouse would inherit that benefit. The problem happens many times is then they get a divorce again and they forget to change it. Okay, I'm going to move on then. Okay, now this gets into the bloodline trust, which is relevant for many, many people. Mary has a house, assets maybe totaling $500,000, has 4 children, just wants everything divided evenly among the 4 children. Wants everything she's built up to go to her children and then eventually go to her grandchildren. But here's what happens. Mary passes away. 1/4 goes to her son, Frank. Frank inherits the money from his mother, and then he commingles it, combines it with his wife, their accounts. Once he combines it, it goes from being a separate asset to a marital asset. Then if he subsequently divorces, his wife may be able to get half of that benefit. So even though his mom wanted Frank to inherit the money and have it eventually go to the children, if there's a divorce, Frank may lose half of the money. The other 25% goes to the daughter, Lisa. Lisa passes away, and what's her estate plan say? Well, her estate plan is going to probably say that her assets go to her spouse, not to the children. Even though mom figured that on Lisa's death, the assets go to the children because she heard in her documents, they have the Latin phrase per stirpes, and the assets would go to the children, her grandchildren, excuse me, if Lisa died. But that only would have happened if Lisa had passed away prior to mom. Most estate planning documents do provide that if you provide assets going to your children and they die prior to you, then those assets will go to your grandchildren, your child's children. But you hope your children will outlive you. If they do outlive you and then they inherit your money, it's then controlled by your child's estate planning document. So in my example, once Lisa inherited the money, in all probability, her estate planning documents just say on her death, everything goes to her husband. And therefore, it's now owned by your son-in-law, not your grandchildren. The next 25% in my example goes to Harry. Now, Harry's a doctor. He gets sued for malpractice. It goes over his insurance limits, and the creditor comes after all that money he inherited from his mother. Obviously not a result that mom wanted. Or, Harry gets in an auto accident, and it goes above his insurance limits. All those sorts of things that could cause him to have a creditor problem. And finally, the one I like the most to talk about is the 25% goes to Larry. Larry is the sort of kid who will spend the money one moment after he inherits it. So, the money's gone. Mom hoped that Larry would save the money. It's all gone. So what can you do to solve the problem? Well, you can't solve it with a will. A last will and testament will not solve this problem. It's the same thing. They inherit the money. You can't solve it with any of my probate avoidance techniques I talked about, a joint bank account or a payable on death account or a transfer on death affidavit, because they're going to inherit the asset, and then it's subject to the same claims. The typical standard living trust doesn't solve the problem either, because most trusts that you will see for most people provide on the death of mom or dad after their children hit a certain age, maybe 25, maybe 30, 35. Once the child hits a certain age, they inherit the money and it's theirs, and you've got that same issue again. Then once it's in that child's name, it's subject to their estate planning documents, it's subject to them getting a divorce or a creditor problem. So you can't solve any of these problems with those standard documents. The only way to solve it is with what we call a bloodline trust. That is a made-up name. You won't find that word in the tax code. That's a made-up name to kind of symbolize what this document does. So what happens is, on your death, the bloodline trust becomes irrevocable. It's divided into, let's say you have 4 children, into 4 separate trusts, one for each child. So, and I'm going to focus just on one child as an example. So the one child will have a trust with their share of the assets in there. They can be the trustee of the trust or not, and I'll talk about that in a moment. And that money in that trust, when it's in the trust, if they get a divorce, the spouse can't get the money. If they have a creditor problem, except for the IRS, state of Ohio, creditors can't get the money. So if they're sued for, malpractice, or they get in an auto accident, or any problem like that, creditors can't get the money. It's protected. So protected against divorce, protected against creditors. And then when the child passes away, it doesn't go to the son-in-law or daughter-in-law. Instead, it goes to your grandchild. So it kept in the blood, or whoever you choose. It could be a niece or a nephew, but in my example, I'm using a child. So it goes to the grandchild. So it keeps it in the blood. And finally, let's talk about the spendthrift, Larry. So in most situations, or many situations, the trustee of the trust is your child. Your child can be their own trustee. They can invest the money any way they want. They can take the money out with pretty broad standards. Government doesn't care about the trust. They don't monitor the trust. The only one who can complain about the trust is the trustee, your child, and possibly his own children. And I can talk about ways to protect you from that. So the government doesn't care. Money's held in trust, invested the way the child wants. Child pulls it out as appropriate. But when the child passes away, what's ever left will go to the grandchild. But Larry, if you make Larry the trustee, he's going to spend the money the next day. So in Larry's situation, many times what you have is a bank trustee, or the other siblings are the trustee. It depends on what you're looking to do. So you have a variety of choices, excuse me again, on who can be the trustee. In a Larry situation, you're going to want somebody else to protect the money. Okay, any questions on that? So a bloodline trust is an excellent tool to keep the assets in the family and protect it. Now, next, I'm going to talk about a variation of a bloodline trust, and that's called a marital trust. Now, let me give you an example. Bob and Jane were married. They had children. They each got a divorce. They met each other. They remarried. Sometimes second marriages last longer than the first marriage. And so Bob, and I could do either Bob or Jane, but I'm using Bob in my example. Bob decides that he wants to provide on his death for Jane to have access to his wealth so she can live in the style that they've grown accustomed to. But Jane promises upon her death, whatever she inherits from Bob will go back to Bob's children, not to Jane's children. Well, that's not going to happen most of the time. What's going to happen when Bob passes away, Jane is going to take that money, combine it with her own funds, and her own estate plan is going to provide it goes to her children. I've had that happen. The second marriage, the kids from Bob's first marriage come in to my office and they say, Dad could not have meant this to happen. Dad didn't want us to write us out. Dad didn't want the money to go to Jane's children. Dad wanted the money to come to us. And Dad did want the money to come to his children, but he didn't have the right document. And it's hard for people to understand. What he should have done is set up a marital trust so that on Bob's death, the money would be available for Jane, but it's in a trust for her. And on her death, whatever left in that trust goes back to the children from Bob's first marriage. That's what Bob wanted. That would have protected the assets. Now, whether Jane is the trustee or not is a whole different issue, and we go into long discussions of that. If he trusts that Jane will be honorable, then he lets Jane be the trustee. If he's concerned, then he has co-trustees, maybe with Jane, or has an independent trustee like a bank or a trust company. Depends on the situation. Because remember, the government isn't watching over this. The only people that are watching over this trust is Jane, in my example, and Jane's children, Bob's children have a right to know what's going on. But they may not know anything bad happens to the funds until long after it's too late. So those are issues. There's no right or wrong answer that has to be, you have to think about. So I encourage you to think about it in a second marriage. Even in a first marriage, we use this for some clients. You might say, well, why? Why would you need to do that? Because Bob and Jane, they're going to provide for their children. Well, let's say Bob and Jane, first marriage, they have children. Bob passes away. Jane meets somebody else. Now, first of all, we'd hope that Jane would get a prenuptial agreement. That's an agreement that says what's mine is mine and you're not getting anything. But maybe she doesn't. Or maybe she does, but she still provides in her estate plan that her assets go to her new husband. Maybe she likes him better. Whatever. She might provide the assets go to the new husband, and then, Bob and Jane's children from their marriage don't receive anything. Or maybe she does the right thing. She provides in her will that everything goes to her kids, but she goes through probate. Under the probate law, her spouse has a right to elect against the terms of the will for 1/3 to 1/2 of the probate assets, depending on certain facts. So even though she did the right thing, it could still end up being a catastrophe. A marital trust solves that problem. It makes sure that the assets are inherited by the surviving spouse. They have access to the money, but on the surviving spouse death, it has to go back to the children. So I encourage you to look at that in your situations if it's appropriate. Again, it's not necessarily appropriate for everyone. Okay, now before I go to the last chart, I'm going to mention a couple things. I see a question or two coming in. I'll take those in a moment. I encourage you, we set up what are called personal planning appointments. At the last chart on this outline, you'll have my email address, or you can call our office and set up an appointment with one of the attorneys in my office, myself or somebody else. And we'll go over your documents. Maybe your documents are fine. We'll say, oh, they're great. You don't have to make any changes. Or we'll come up with some recommendations. We charge a flat fee for the meeting of $200. And then at the meeting, if there's something more to do, we'll tell you what it is we propose to do, and we'll give you a quote for the meeting. The meetings usually last an hour and a half to 2 hours, depending on your situation. Most people find them valuable. I encourage you to either email me or email our office, or give me a call or give our office a call, and we'll be glad to set up a meeting with you. And we have 3 offices I forgot to mention. Our main office is in Mayfield Heights. Once we start meeting people again, we also meet in our Independence office and our Westlake office. Right now, we're encouraging people to attend meetings by Zoom or by phone. We will start meeting people in person, but we're still trying to discourage it if possible. So I encourage you to sign up for one of those meetings. I think you'll find it valuable. Now I'm looking at one of the questions. It is, would these trusts be taxable as a trust and lose the benefits that an individual gets? I think I know what the question is. First of all, while you're alive and you set up these trusts, they're called revocable, means you could change them. So from an income tax purpose, while you're alive, there is no change in the tax treatment. So it all shows up in your 1040. The trust doesn't file a separate income tax return. So you get the capital gains rate that you get. If you sell in a home, your home, the first $250,000 is exempt from income tax. If you're a single person, $500,000 if you're married. You get all those tax benefits. On your death, the tax rules change. The trust is a high income tax payer, pays at a very high rate very quickly. After like $13,000, it pays at the highest income tax bracket. So we do tax planning once the trust becomes irrevocable. So for example, if the trust earned ordinary income, we would probably pay that out of the trust every year to the beneficiaries, so the trust won't pay any income tax if they distribute that money out during the year. The beneficiary will at their bracket. There's other planning to do with capital gains. It gets real technical, and I can get into it later. But after the person passes away, we try to work with them and their investment advisor to make them the best tax investment planning, or to make sure you follow the tax rules to reduce the taxes to the trust to the extent we can. So that's what we do in those situations. The next question is, do I need to have both a bloodline trust and a marital trust in separate documents? No. Okay, so I talked about bloodline trust, and I talked about marital trust, and you can have separate. You can have one document that covers all of that. Actually, that looks like that was a question from the last seminar. So I'm not sure why on my screen questions from both are pulling up, but I don't know if you see those, but I don't. I mean, whether you see that. Okay, so let me move on. I apologize. So any other questions on that before I continue? Okay. Let's see. Now this trust, very few people should do. Okay, I do see one more question. If a child inherits property through a trust, does he still get the step up in basis? Okay, so let me explain how that works. So if you set up this trust, you put the Google stock in there. While you're alive, it's a revocable, not irrevocable, revocable trust. So on your death, there is still a step up in basis in the Google stock. So that capital gains are wiped out. However, depending on what we do with the trust that's in this bloodline trust for your child, on their death, the assets that are in that bloodline trust may or may not get a step up of income tax basis. We can design it either way. It depends on whether we're concerned about whether the child will have an estate tax problem or not. So we can design it both to get a step up in basis on your death, and then subsequently on a bloodline trust when the child passes away, they can get another step up in basis. So we can design it that way. Okay, so now I'm going to move on. The Ohio Legacy Trust. Very few people should use this. This is very limited. Let me give you the background. We inherited from England the theory that you could not set up what are called self-settled trust for yourself, and protect them from creditor claims. For example, if you set up a standard revocable trust, that's not protected against any of your creditors. If you have a creditor problem, they can grab the money. Many states over the years have been adopting what's called a domestic asset protection trust. Ohio calls it the Ohio Legacy Trust. It's irrevocable. You set it up immediately. It's an irrevocable trust, and the assets in this trust are protected from any creditor claims except the IRS. They're protected against creditor claims. And also, if you already have a creditor coming after you or threatening you, it's not going to protect you there. So it's not protected from the IRS, not protected from existing creditors, not protected from child support payments in most situations, and not protected from spousal claims. Now, make sure you understand what I'm saying. If you get a divorce, your ex-wife or ex-husband doesn't get the money, but while you're married, you have a legal support obligation of your spouse. They would have access to the money. But other than that, it's protected against any other creditors. You cannot be the trustee of this trust. Someone else, an Ohio resident, has to be a trustee of the trust or a bank. But if it's drafted properly and you put your assets in this Ohio Legacy Trust, you don't have any of these other creditors hanging around, you will protect those assets from creditor claims. Again, very few people should bother doing this. It's an expensive document. I wouldn't recommend it just willy-nilly, but that is one of the tools that's available now under Ohio law. It was adopted, probably around 4 years ago. So that covers my topics. As I mentioned before, if you have any questions, please email me or send a letter or call our office. If you want to be on our list to receive newsletters or notices of upcoming seminars, we're going to try to do these every 2 weeks or so. Please get your name on the list. I suspect if you're attending this, you're already on our list, but if not, certainly ask to be put on the list. I'll hang around for a few minutes after I'm done here and be glad to answer any of your questions. And thank you for coming, and be on the lookout for our upcoming seminars. Thank you very much. Okay, well, I see no one's has any questions, so I'm going to hang up. You all have a good day, and see you next time. Thank you very much.